Judge Shapiro, we are a few minutes early, but I just wanted to let you know that everybody's here and we can start whenever you're ready. Would you like me to bring them in?
Yes, please. Good afternoon, gentlemen.
Good afternoon, Judge.
I'm going to hear the motion, but I don't want to forget that if this motion is not granted, that we need to talk about scheduling, because I think the scheduling order issued by Judge Stevens is now out of date. Okay, with that, I'm going to call the case and we can begin. This is the matter of Suleyman Uludag versus University of Michigan-Flint, Court of Claims number 20-213MK. And this is, we have two motions actually, defendant's motion to summary disposition and plaintiff's motion to amend, and they're pretty intertwined. I'm not going to have you argue them separately. And so we'll begin then with Mr. Baker, if you put, I'm sorry, it's Mr. Is it Mason or Masson?
It's Masson.
Masson, okay. Mr. Masson, it's your motion, so if you put your appearance on the record and go ahead.
Yes, David Masson, representing the University of Michigan.
Go right ahead.
So there are, as the judge recognized, there are two motions: the university's motion for summary disposition and plaintiff's motion to amend. I will deal with the motion to amend and the notice provisions sort of together at this point. So I recognize, and the university recognizes, that plaintiff's right to amend his complaint is currently controlled by the case of Uludag versus University of Michigan. It's a published decision. The university contends that decision has been wrongly decided, but I certainly understand that the court, sitting as a court of claims judge, is controlled by the published opinion of the Court of Appeals. Oh, I'm sorry, Judge.
Oh no, I was just making a joke. I apologize. You go right ahead.
Okay. So I understand that, but I wanted to have on the record the university's position that it was wrongly decided, and I will rely on my brief for that argument, and then I'll move on to the motion for summary disposition. And I really won't address the notice provision, the requirement of a verified complaint. I think that's all set forth in the brief. I will deal with the merits of the motion.
Thank you.
So factually, just briefly, Judge, on February 4th of 2019, the plaintiff informed the university that he was detained in Turkey, that he had been detained, and it ultimately turned out he was detained on terrorism charges in Turkey. The university ultimately replied to the plaintiff with sort of three options to maintain his employment. So those options were to continue on his fully paid sabbatical, which was scheduled to last till December 31st of 2019. He would have been fully paid and received benefits. 2, he could have moved to a full year sabbatical that would last to June 30th of 2020. But of course, his pay then would be half pay, but full benefits for that period of time. And then finally, he could be placed on an unpaid leave of absence. Plaintiff didn't respond with an acceptance of any of those options, and the university determined to leave him on the previously scheduled fully paid sabbatical to December 31st, 2019. On November 19th of 2019, the university sent an email to the plaintiff asking whether he would be back in Flint, in the United States, in January of 2020 to teach his classes and perform his faculty obligations. Plaintiff on November 29th, 2019, he assured the university that he would be back and that he would be able to carry on his faculty obligations. On January 2nd of 2020, mere days before his classes were scheduled to begin, the plaintiff indicated that he was still detained in Turkey, that he was unable to return to Flint to teach his classes, and that he intended to teach his classes online. Now, it's important to note, and it's not contested, that plaintiff was scheduled to teach 3 classes beginning in January, and all 3 classes were posted for students as in-person classes. The classes, plaintiff understood they were in-person classes, they were posted as in-person classes. Yet days before, plaintiff said, well, I can't get back, so I want to teach my classes online. The dean responded to the plaintiff, indicating that because the classes were posted as in-person, she would not convert the classes to online classes, and that she was assigning another faculty member to teach the classes. Plaintiff was also told that if he would return, if he was able to return by February 3rd of 2020, his pay would be continued. He would be assigned to teach the remainder of the classes, and we would move on. On February 3rd of 2020, he didn't return. He wasn't able to teach the classes, and he was told on February 3rd that he was being placed, he was told on February 4th that he was being placed on an unpaid leave of absence. And that's Exhibit 5 to the university's original motion. And he was told that he would remain on an unpaid leave of absence unless he was able to return by April 1st. If he returned by April 1st, he would be assigned other duties. And again, he would be returned to the payroll. He didn't return on April 1st, wasn't assigned other duties, and ultimately did not return until June 11th of 2020. Plaintiff's claim in this case is that there is a contractual agreement that plaintiff can only perform part of his duties and still be paid full pay. That is, plaintiff has presented no contract, no agreement, no promise to support that. Plaintiff was unable to teach. University policy is clear that teaching is a core function of the faculty. And that was cited in my original brief at Exhibit 9. Plaintiff was unable to perform a core mission. Now, plaintiff contends, well, I could have taught online. I offered to teach online. Again, the university's policies gives the dean the authority to determine the location of work, gives the authority to determine where classes are to be taught. The dean was very clear. The classes were posted as in-person, and I'm not changing that because they were posted as in-person. Plaintiff now contends, of course, that in March, when the pandemic hit and everyone went on to online, I should have been allowed to go on. Again, the dean has explained why that was not allowed. At that point, in mid-March, the classes had been taught by alternate faculty members for 2 months. There was less than 1 month left in the class, and she was not willing to disrupt the students' education any further by substituting in the plaintiff for the ongoing faculty members. And again, under university policy, the dean has that right to determine that issue. And I would cite to the court the case of Dumas versus Auto Club Insurance. It was cited in my brief. It's found at 473 Northwest 2nd, 652. In that case, the court stated a couple of things. First of all, the court stated that the courts should be reluctant to interfere with the employer's implementation of its policy decisions. I'll just read from page 531 of the Dumas opinion. Our opinion in recertified question was in furtherance of this court's traditional reluctance to limit or second guess the decision-making ability of business management. As stated in Butterfield Estate, 418 Michigan 241, a court must be most reluctant to interfere with the business judgment and discretion of directors in the conduct of corporate affairs. In this case, the plaintiff's contract, the plaintiff's and the university's policies said several things. One, teaching is your core job. Two, that the dean had the right to determine where teaching would occur. The location of work, the dean had that authority. And three, that the dean had the authority to place the plaintiff on an unpaid leave of absence. And that is cited in my reply brief that University SPG 201.30, that's Exhibit 10 attached to the reply brief, allows for the university to place an employee on an unpaid leave of absence. What the plaintiff has argued here is, well, I wasn't getting paid, so the university must have suspended or fired me. No, the university applied its policy to place the plaintiff on an unpaid leave of absence. After the plaintiff returned and was able to take on his duties, he was removed from the unpaid leave of absence and his pay continued. This was all within the policies of the university. This was all within the policies that covered the grievance, the plaintiff's employment. The plaintiff has presented absolutely no contractual agreement that he could forego a core part of his job and continue to be paid. If the court grants plaintiff's argument, it entirely deletes the authority of the dean to determine that you will teach in person, that classes will be in person. An employee could say, I'm not coming in today. I'm not going to be here. I'm sorry. Not going to work today. And under plaintiff's theory, that employee is entitled to continue to be paid, unless the university moves to the draconian methods of suspending or firing the employee. That wasn't the case here. The university was not alleging that the plaintiff committed some type of misconduct that determined his suspension, that required him to be discharged. He just wasn't able to work. And so he was properly placed on an unpaid leave of absence.
Okay. Mr. Baker and Mr. Maffron, you can rebut, of course, after this presentation. Go ahead, sir.
All right, thank you. Good afternoon. Good afternoon, Your Honor. James Baker on behalf of the plaintiff, Suleyman, Uludag. First of all, on the motion to amend, I've laid out the arguments. I think that not only Elia, but we look at Progress Michigan, which is a Supreme Court case that directly addressed fairly.
From this level with your argument, that's that's decided by the Court of Appeals, and as far as I'm concerned, the motion to amend is stands now.
Okay, thank you, Your Honor. In regard to the motion for summary disposition, Mr. Mason's arguments are all well and good if we're talking about a traditional at-will employee who has one job and one duty. We have a tenured professor who had a triumvirate role within the university, as laid out in the position description provided by the university: teaching, research, and service. We have an express mechanism by the university to demote, suspend, all the way to terminate a tenured employee, including for an inability to do his job. So I know Mr. Mason wants to talk about this draconian kind of, fraud, bad faith, illegality in the performance of his duties, which are traditional ways that tenured professors are removed. But one of the ways that the bylaws of the university applies to even taking away a professor's pay is whether he's able to do his job or not. And that's spelled out expressly in the bylaws. And that is the president is to take the action, is to appoint the panel, the 3-member panel, to evaluate whether or not a tenured professor should go all the way from a suspension, demotion, all the way to termination. I don't disagree that the dean has the ability to control her college. I do disagree that the dean has the ability to cut off a professor's source of income and benefits when circumstances were beyond his control. It creates, his detention in Turkey created an impossibility of performance with regard to the teaching component. Now, what Mr. Mason doesn't discuss today is the university relied on Professor Uludag from February to June. They asked him to do the work. They required him to do the work. They kept him in communication. The dean did not cut my client off from communications with the university. The dean did not instruct my client, you are absolutely forbidden during your leave of absence to even communicate with the university. You are persona non grata for the period of time that you're out of the country. He still had to perform his research. He still had to do his service work. He offered to teach. And so that's where this March 11th date is really important, because just like his detention in Turkey was out of his control, the pandemic hit, and that put all of the professors, that put the ability to teach in person out of the control of all professors. So as of at least March 11th, he was on the exact same footing as every other professor. He could, and this concept that if he would have returned on April 1st, he would have been assigned other duties and received his full pay. Why wasn't he given those other duties remotely on March 11th when everybody else was given duties remotely on March 11th? So the argument goes, if you don't teach, you don't get paid, and it's my discretion, tenured professor, contrary to what the bylaws of the university say. But we're still going to make you work. We're still going to put you to work. You're still going to provide benefit to the university. You're going to do the research. You're going to participate in advancing the name of the university through these high school programs, through these tenure committees. But we're just not going to pay you. It would be far different, Your Honor, if the university had cut him off and said, you are to do nothing. They did not do that. They just said, you can't teach online. And this is a computer science course. This is not, I guess the best argument would be some type of human biology course where you need to dissect something in person and look through the pieces parts. This is online work. And in fact, the university has gone to online in the computer science department predominantly now after the pandemic. Your Honor, I think ultimately it comes down to that fundamental issue. If they would have cut him off, if they would have severed him and said, when you come back, we will revisit, but you are to do nothing, then I might see the argument. But they didn't. They relied on his work. They put him to work. They ordered him to work. And we laid it out in his affidavit, everything that he did. And there's a predominant amount of work there. So I think at the end of the day, I think there's a question as whether or not he should be paid for the work. I think there's a question of fact whether or not he is on the same and equal footing as every other employee as of March 11th, and whether if he's not to be paid for the entire time, February 4th to June 30th, should he be paid from March 11th through June 30th? I'd ask that the motion be denied on the substantive basis and as well denied on the procedural basis regarding the notice requirement under the statute.
Just,
Mr. Masson, could you respond to the issue of his performance of other activities, and research and service?
that is exactly where my response is going to be, Judge. Plaintiff's argument is if he had been told on February 4th, don't do anything, or we're cutting off your email, don't do anything, then that would have been okay. But he was essentially told that, although they didn't say that in so many words. He was told the following: you are being placed on an unpaid leave of absence. So he knew as of February 4th that he was on an unpaid leave of absence. The policies for an unpaid leave of absence are you're not able to work. And so he was told that. He was also told that if you return by, I believe it was April 11th, I think the plaintiff may have said March 11th, but if you return by April 11th, we will assign you other duties. So he knew that while he was in Turkey, he was not to be performing any duties. He was on an unpaid leave of absence. What plaintiff's affidavit does not indicate is that someone in authority at the university ordered him to work. Plaintiff chose.
I understand your argument, but let's take an example. He on his affidavit, one of the things he listed was that he was involved in peer review of several journal articles during that time. I mean, that's certainly something that's part and parcel of his activities at the university, isn't it? Even though it's for a different publication, I mean, that's something professors are expected to do.
Yes, Your Honor. I'm not disagreeing that at least some of the work. I mean, I might argue that all of the things that are in that affidavit are not appropriate, but certainly some of them are the kind of work that faculty members do. But that doesn't lead to a breach of contract claim. So because he doesn't have a contract that says you are entitled to be paid for parts of your job. You're entitled to be paid, let's say a third for doing a peer review. Plaintiff hasn't cited to anything that says that. And to the extent that he was doing work, plaintiff should have, if he didn't know whether he should or shouldn't, send an email to the dean, ask the dean, ask your boss, what should I be doing? He didn't do that. He just moved ahead and continued to do work he hadn't been ordered to do, even though he knew that he was placed on an unpaid leave of absence.
Let me look at my notes.
Oh, and just one final point, I would say he could have grieved over those issues.
He could have grieved, did you say?
Yep, there's a faculty grievance process. That was cited in my reply brief, Judge. Okay. And it was really in response to plaintiff's claim that there was somehow a discharge and there was no due process. Well, he had the ability to grieve and he didn't do so.
So is it correct then that the professors at University of Michigan don't have contracts as such?
So they do not have contracts. What they have essentially are the various policies that control employment. So just like I don't have a contract, Judge, I'm an employee of the university. I've been hired by the university. My employment is governed by all of the policies that exist at the university, giving my boss a lot of rights to control whether I'm going to do an oral argument, whether I'm going to get paid if I say I can't do an oral argument, for example. So it's not any different for a faculty member.
Your Honor, can I add one point?
Yes, you can.
Mr. Masson is not a tenured professor at the University of Michigan. Tenure controls. And we also have the fact that the university directed work to him, not just him doing work on his own for the university.
Tell me why tenure matters here, since a tenured professor can be placed on a leave of absence, right? I mean, is that?
I don't.
They can?
I believe the tenured professor can be placed on a paid leave of absence. Absolutely. I think once you affect money, you have to follow the bylaws. The president has to institute the 3-member panel and follow through with tenure because it is an adverse employment action. It's just like a suspension, a demotion, and akin to a discharge, because if Dr. Uludag could not have come back in July, the dean was threatening his position at that point.
Right. All right. I don't have any other questions, gentlemen. I did want to touch base here on this scheduling order. This is a matter that if I deny the summary disposition motion, we'll have to have a trial absent a settlement. So I'm looking at the scheduling order, which said as early as March 22, 2022. So I think we're past that. I don't have any trial scheduled at the moment, and other than the month of August, I'm pretty much available. How do things look on your calendars? Or do you want, what I could do is issue the opinion, and if it's a denial of the SD, then I'll schedule a prompt status conference, and you should come prepared with dates.
I think that's a good idea, Your Honor, because I'm right now, both my federal trial dockets and my state trial dockets are filling up for the end of the year and into 2023. This is a bench, or this is I think probably no more than a 2-day bench trial here, but in the sense that I have, I'm getting called and tasked on a lot of things that I don't know what my calendar is going to look like after August. So I think a scheduling order after, or scheduling conference after decision would be appropriate.
Okay.
Thank you.
I agree with that.
Good. All right, gentlemen, then the hearing is concluded. I'm going to sign off, and the court reporter probably will want to know if you wish to order. All right.
Thank you, Judge.
Thank you, Your Honor.
Do either of you gentlemen request transcript?
Plaintiff does not.
I don't need a transcript either.
Okay. All right, great. Thank you, gentlemen.
Have a good day.
Bye, you too.
All right, thanks.